Hey folks, Elder Law Care Attorney Patrick Kelleher coming to you from elderlawcare.com. Folks, today's question, hey Patrick, what assets are at risk for the metaphorical fourth-headed monster, Medicaid, Mass Health here in the Commonwealth? Well, for a married couple, what assets are at risk? Well, you name it, they're going to take a look at it, right? For the most part, okay? Let's first talk about exempt assets here in the Commonwealth. An exempt asset would be your principal residence, your primary home, but not a second or subsequent home. Principal residence only, up to over $1 million now in equity. If you have a house worth more than that, then only the exemption amount is up to like $1 million, maybe 70,000 now. It goes up every couple of years. So keep an eye on that. So your principal residence only, folks, not second, subsequent homes. Also, folks, what else is exempt asset is automobile. One automobile. Okay, that's it. One automobile. Also, what is exempt would be an irrevocable funeral contract. Irrevocable funeral contract. Also, a burial plot. Things of that nature. So they're the big staples that are usually exempt. What the Medicaid Mass Health Department will look at for eligibility is your other assets, your bank accounts, your investment accounts, additional pieces of real estate other than your principal residence, things of that nature, are all computed into your estate for eligibility requirements, what they call the asset and income eligibility test, two-prong test right there. So that being said, here in Massachusetts, for a married couple, if Bill and Mary are a married couple and Bill needs to go to a nursing home and he needs to apply for Medicaid benefits to pay for that $15,000 to $20,000 per month nursing home, Bill's not going to qualify unless he has less than $2,000 of assets in his name, $2,000 or less, okay? If he has more than that, he can transfer some of his assets or the rest of his assets to his wife, Mary, in the community, but only up to about $154,000 in change, okay? If Mary has more assets than that, they're looking at the couple's assets as a whole, then there's a problem, because then they're going to have to do spend downs. The spend downs that I just mentioned a moment ago, if they don't have an irrevocable funeral contract, they can purchase one. If they don't have a burial plot, they can purchase one. If they don't have an automobile or they need a new automobile, they can purchase a new one, okay? So there's permissible spend downs that they can undertake that will help them spend down. One of the biggest spend downs would be for medical expenses, things of that nature. And so not a lot of spend downs if folks have a very large estate. They can then take some of those excess assets and convert them to an income stream, what the crisis planning strategies call Medicaid compliant annuity or a single premium immediate annuity, okay? So that is not ideal. That is raw crisis planning, because then you need to work with your financial team, your elder law attorney, your financial person, maybe your CPA, to see what the tax implications would be there if you're liquidating a qualified retirement account, which is not ideal, like a 401k or an IRA, and you're converting that asset to an income stream with a Medicaid compliant annuity. Not ideal, but that is one of the few Medicaid crisis planning strategies available, okay? Because they took away one of our preferred ones called the Community Pooled Trust recently. Not able to use that any longer. So basically all excess assets over $154,000 in change for the community spouse are at risk. So really, really important. From my experience, folks, the best medicine is to beat that 5-year look back period and take action when you're alive and well, maybe third quarter of life when you're alive and well, before you become alive and not so well, either you or your spouse, Bill and Mary at home. Meet with your experienced elder law attorney, create an irrevocable Medicaid asset protection trust, and transfer your treasures. Oftentimes, like my late parents, their family home is oftentimes the largest asset, and maybe some other assets after a careful assessment and evaluation to beat that 5-year look back period. So in the event either of you or both become alive and not so well in the future, at least significant amount of your assets, the larger assets, are off the table, so long as you beat that 5-year look back period and the trust was done properly in compliance with Medicaid rules and regulations. Folks, there you have it right there. Proceed with caution. If you're of age, 65 and over, strongly recommend meet with an experienced elder law attorney to carefully assess and evaluate the nuances of your matter while you're alive and well, third quarter of life. So when you reach the fourth quarter of life, you'll be well prepared. Folks, there you have it right there. Elder Law Care Attorney Patrick Kelleher. If you found this video, please share it with others. Please click the subscribe button and click that notification bell, because we will keep you updated when new videos are released. So you'll be better positioned to slay that metaphorical four-headed beast of estate planning in elder law. If you have not read my book yet, please pick up a copy on Amazon. Attorney Patrick Kelleher, How to Slay the Four-Headed Beast of Estate Planning and Elder Law, because it will teach you how to slay that four-headed beast for you and your loved ones. Folks, thanks for joining us here today at elderluckcare.com.